Jefferson County Court Law number 2 is now in session. Next case is cause number 323250. Case of South State of Texas versus Thomas Pulliam. Mr. Pulliam, is that your full name?
Yes, Your Honor.
Mr. Pulliam, would you please raise your right hand? Mr. Pulliam, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, Your Honor.
Mr. Pulliam, you may put your hand down. How you doing, Mr. Pulliam?
Doing well, Your Honor. Yourself?
I'm doing fine. Thanks for asking. Mr. Pulliam, you're here represented by your attorney, Attorney Ryan Gertz. Attorney Gertz, how are you doing?
Great, Judge. Thank you.
And Mr. Gertz, do you waive a record in Mr. Pulliam's case?
Yes, Judge.
And the state is represented by Attorney Lamar Johnson. Attorney Johnson, how are you doing?
I'm good, well, Your Honor. Thank you.
That's good. Mr. Pulliam, did I swear you in?
Yes, Your Honor.
Yes.
Okay, Mr. Pulliam, I have before me a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. This information alleges that on or about January 31st of 2019, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of prostitution. Do you understand what you've been charged with?
Yes, Your Honor.
And to this charge, Mr. Pulliam, how do you plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
Now, are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you are guilty?
Yes, sir.
Okay, Mr. Pulliam, I also have before me a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes, Your Honor.
And on the next page of the same document, there are a set of initials, PP, that are on a line next to a box that's checked guilty. Are these your initials?
Yes, Your Honor.
On the next page of the same document, there's a signature above the line that is titled Defendant. Is this your signature above the line that's titled
Yes, sir.
Defendant? Next document is titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document?
Yes, Your Honor.
Mr. Pulliam, is this your signature on the line that's titled
Yes,
Defendant?
Your Honor.
There are two boxes that's checked at the top of this document. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, Your Honor.
Second box states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that?
Yes, Your Honor.
You had a discovery search. Mr. Pulliam, I also have a document before me that's titled Discovery Certification. You recognize this document?
Yes, Your Honor.
And is this your signature on the line that is titled Defendant?
Yes, Your Honor.
Now, Mr. Pulliam, before you signed and initialed all of these documents that I've just mentioned to you, did your attorney, Mr. Gertz, go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, Your Honor.
And is everything in these documents true and correct to the best of your knowledge?
Yes, Your Honor.
Mr. Pulliam, are you a citizen of the United States?
Yes, Your Honor.
State, I have before me State's Exhibit number 1. State, you like to offer States 1?
Yes, Your Honor. State offer stage one.
Any objections?
No, Judge.
No objection. State's Exhibit number 1 will be admitted. Mr. Gertz, you advised and counseled Mr. Pulliam. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Judge.
Mr. Pulliam, your attorney, Mr. Gertz, has advised and counseled you. Are you satisfied with his representation?
Yes, Your Honor.
Has he provided fully effective and competent legal representation?
Yes, Your Honor.
Mr. Pulliam, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
Your Honor, in exchange for the defendant's plea of guilty in this case, the state is recommending, excuse me, that the court suspend imposing, deferred imposing guilt at this time, Your Honor, and instead place the defendant on community supervision for a period of 6 months, Your Honor. Require the defendant to pay a $500 fine and to complete 24 hours of community service.
Mr. Pulliam, the state is offering that you serve 6 months of deferred adjudicated probation. During this 6 months probationary period, you'll be required to pay a fine of $500 plus court costs of $307, which comes to a total of fine and court costs of $807. You will also be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month. You'll be required to pay monthly installments. That is, you'll be required to pay for the total, while you're on probation, a total of $240 each month. Mr. Pulliam, will you be able to pay the $240 each month?
Yes, Your Honor.
Mr. Pulliam, you'll also be required to perform 24 hours of community service, and you'll be required to adhere to the other standard terms and conditions of this probation. Now, Mr. Pulliam, do you understand the state's offer?
Yes, Your Honor.
Do you think that the state's offer in your case is fair and just?
Yes, Your Honor.
And do you accept the state's offer?
Yes, I do, Your Honor.
Mr. Pullum, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Mr. Pullum, if you successfully complete this probationary period, this case will be dismissed. It would not result in a conviction on your record, and you may qualify for non-disclosure. You can talk to your attorney, Mr. Gertz, about the non-disclosure because he's quite competent in those matters. And Mr. Pullum, you're gonna stand on the X next to your attorney, follow the directions of our clerk. Once you finish following her directions, you'll be free to go, and you have a blessed day.
Thank you, Your Honor. You too.
Thank you.
Mr. Fuller, can I get your right thumbprint on that blue light in front of you, please? Oh. Okay. Now, Mr. Fulham, can I get your signature on that signature pad located in front of you? You won't be able to see it, but I will. Now, Mr. Gertz, can I get your signature, please? Thank you. Now, Mr. Fulham, can I have you raise your right hand, please? Do you swear that you've never before been given probation, regarding adjudication for a felony or misdemeanor, Texas, or any other state? Okay, and you have no other pending charges that you're aware of? Great. Okay, you can put your hand down. So this is your paperwork. I attached the map on how to get to the probation office. You'll report here as soon as you leave. But before you do,
She's got
leave, you have a valid form of identification. with
You, what you're looking for the discovery? It's on that
I don't
side.
need it. You're gonna take this order.
In the
downstairs to
front,
county clerk's
right there.
office.
Yeah, that, you have your hand on it.
So you'll take this paperwork, this, and your ID, then this, the first floor. If I said, have your signature. That's everything.
Next case
Make sure you pick up
is cause number 329-725.
first
The
floor
case
sign.
is styled State of Texas versus Michael Wayne Wilcox. Mr. Wilcox, is that your full name?
Yes, Your Honor.
Mr. Wilcox, would you please raise your right hand? Mr. Wilcox, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
I do.
Mr. Wilcox, you may put your hand down. How are you doing, Mr. Wilcox?
Oh, well, how are you?
I'm doing fine. Thanks for asking. Mr. Wilcox, you're here represented by your attorney, Attorney Ryan Gertz. Attorney Gertz, do you waive a record in Mr. Wilcox's case?
I do, Judge.
Mr. Wilcox, I have before me a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. This information alleges that on or about May 1st of 2021, while you were operating a motor vehicle in a public place in Jefferson County, Texas, that you committed the Class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more. Mr. Wilcox, do you understand what you've been charged with?
Yes.
And to this charge, Mr. Wilcox, how do you plead? Guilty, not guilty, no contest?
Guilty.
Now, are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you are guilty?
Yes.
Mr. Wilcox, I also have before me a document that is titled misdemeanor plea admonishment. Do you recognize this document?
Yes, Your Honor.
On page 2 of the same document, Mr. Wilcox, there are a set of initials MW that are on the line next to a box that says guilty. Did you place your initials on this document?
Yes, Your Honor.
On the 3rd page of the same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, Your Honor.
The next document is titled trial court certification of defendant's right of appeal. You recognize this document?
Yes, Your Honor.
And is this your signature on the line that's titled defendant?
Yes.
There are 2 boxes that's checked at the top of this document. The first box that's checked states that this is a plea bargaining case and you have no right of appeal. Do you understand that?
Yes.
The second box states that you're waiving your right to appeal, which means you're giving up your right to an appeal. Do you understand that?
Yes.
And I also have before me a document that is titled discovery certification. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant? Mr. Wilcox, before you sign and initial all of these documents that I just showed you, did your attorney go over these documents with you?
Yes.
And did you read and understand everything in these documents? And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, state, I have before me state's exhibit number 1. State, you like to offer states 1?
Yes, Your Honor, state on state one.
Any objections?
No, Judge.
And Your Honor, the state would also like to offer at stage 2, the probable cause affidavit that I believe is in the court file.
Okay,
We have
any,
no objection.
any objections? Okay,
Yeah, and we'll waive reading of that.
okay, states exhibits 1 and 2 are admitted into evidence. And the court will take judicial notice of State's Exhibit number 2. Mr. Wilcox, are you a citizen of the United States?
Yes, sir.
And Mr. Gertz, you advised and counseled Mr. Wilcox. Is there any evidence that he is currently mentally incompetent to stand trial?
None, Judge.
Mr. Wilcox, your attorney, Mr. Gertz, has advised and counseled you. Are you satisfied with his representation?
Yes, Your Honor.
Has he provided full, effective, and competent legal representation?
Yes.
Mr. Wilcox, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
What is that agreement?
Your Honor, in exchange for the defendant's plea of guilty in this case, the state is recommending confinement in the Jefferson County Jail for a period of 90 days, Your Honor. We're asking that the court suspend imposing that sentence at this time and instead place the defendant on community supervision for a period of 1 year. Your Honor, require the defendant to pay a $500 fine to complete 24 hours of community service. We're also asking that the terms and conditions of the DWI include DWI education course, drug and alcohol assessment, and interlock device.
Hey, Mr. Wilcox, the state is offering that you serve 90 days in Jefferson County Jail. However, you will not have to serve any time in the Jefferson County Jail in this case because you'll be placed on probation for 1 year. During the 1 year probationary period, you will be required to pay a fine of $500 plus court costs of $422, which counts a total of fine and court costs of $922. You will also be required to pay a probation fee, $60 each month, or your analysis fee of $15 each month. You'll be required to pay Jefferson County DWI education class and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, your total monthly installments, that is the total amount that you will be required to pay while you're on probation, is $160 each month. Mr. Wilcox, will you be able to pay the $160?
Yes, Your Honor.
You will also be required to perform 24 hours of community service, install an interlock device on any vehicle that you own or operate, attend and complete a DW education class, and have a drug and alcohol assessment. And you will also be required to adhere to the other standard terms and conditions of this probation. Mr. Wilcox, do you understand the state's offer?
Yes, Your Honor.
Do you think that the state's offer in your case is fair and just?
Yes,
And do you accept the state's offer?
I do.
Mr. Wilcox, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Wilcox, this will conclude your case. You're going to stand on the X next to your attorney, follow the directions of our clerk. Once you finish following her directions, you'll be free to go, and you have a blessed day.
You too, thank you very much.
Thank you.
You're welcome.
Your right thumbprint on that blue light in front of you. Thank you. You can remove your thumb. All right, and Mr. Wilcox, can I get your signature on that signature pad located in front of you? You won't be able to see it. But I will. Okay, now, Mr. Kurtz. Now, Mr. Wilcox, can I have you raise your right hand? Do you swear that you've never before been given probation or deferred adjudication for a felony or misdemeanor in Texas or any other state? Okay, and you have no other pending charges that you're aware of. So this is your paperwork. You're gonna take it to the probation office. As soon as you leave here, I've attached a map on how to get there, and you're good to go.
Destiny Marie Kennett. And you have a blessed day, Mr. Gertz.
Thank you, Judge.
Okay. Jefferson County Court at Law number 2 is back in session. Next case is cause number 331-492. Case is styled the state of Texas versus Destiny Marie Kennett. Is that your full name?
Yes, sir.
And would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, you may put your hand down. How are you doing?
Good.
I'm doing fine. Thanks for asking. You're here represented by your attorney, Attorney Wright Kimler. Attorney Kimler, how are you doing?
Well, thank you.
Mr. Kimler, do you waive record in Ms. Kennett's case?
We do.
Okay, Ms. Kennett, I have before me a document that is titled Information. This information alleges that on or about October 15th of 2021, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of driving while intoxicated with alcohol concentration level of 0.15 or more.
Now, just to be clear, I think that's a Class B misdemeanor with a Class A punishment range. And if you look at the admonishment that she signs, it did references that in Class B.
So y'all,
It's a class A misdemeanor, Your Honor, if we can offer into evidence a PC affidavit supporting the point.
If you could look at the admonishment that on the page that she signs, it references that above a 0.15 is a Class B misdemeanor
oh,
on the documents.
oh, you say on this here? Oh,
Right.
wow.
If you look at what's X, the offense level that's charged, it references a Class B misdemeanor.
I think what they represent is being a DWI first, but the punishment range is different.
It's a Class A punishment range, but it's not actually a Class A misdemeanor. I think it's a Class B misdemeanor with a Class A punishment range.
For purposes of this.
Oh, I mean,
I know, for the purpose of this, Judge.
I'm just gonna go with, say what the code call it.
But see, there's a conflict between what she's signing and what she's being orally admonished if we do it this way.
No. What I'm admonish you to the Class A misdemeanor.
But what's X is a Class B.
I know, but I mean, I don't know who X'd that, but
I did, because it's a DWI first with a point over a 0.15, which is what she's charged with.
Okay, hold on a minute. Let's go to 49.04 D. If it's shown on trial under the section that the analysis of level more the time the analysis form, the offense is a Class A misdemeanor.
She's pleading to a class A, Your Honor.
So why does that say Class B?
This here paperwork, this is for DWI first with the level below a 0.15 or more. But the punishment range, the way the legislature wrote the law, it's a Class A misdemeanor.
But that needs to be changed in because.
I mean, yeah, so I don't check this box. I check the Class A box because it's a Class A misdemeanor. Because the B starts off with a minimum jail time of 72 hours to 365 days. But Class A has 0 days to 365. You understand what I'm saying?
But referencing on that paperwork, it references in the section.
Yeah, I mean, I can scratch through that.
The references above
Yeah.
a 0.15.
There's no difference in the court anything that.
Yeah, I can scratch through that and just yeah. Yeah, but it's a Class A misdemeanor.
As long as she's admonished correctly. And
Yeah, okay.
correctly reflects what she's been orally admonished.
Okay, that's what I'm gonna admonish her right now. Now, Miss Kennedy, the punishment range for this offense is a Class A misdemeanor, and the range of punishment is confinement in jail for a term not to exceed 1 year, a fine not to exceed $4,000 of both such confinement and fine. Do you understand that?
Yes.
Okay. Now, on page 2 of this same document, there are a set of initials on a line that's next to a box that's checked guilty. Do you recognize?
Yes, sir.
Is this your,
Yes,
are these your initials?
yes,
On page 3 of this same document, there's a signature above the line that is titled defendant. Is this your signature?
yes, sir.
On the next document that is titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature above the line that is titled defendant?
Yes, sir.
There are 2 boxes that's checked at the top of this document. The first box that's checked states that this is a plea bargaining case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box that's checked states that you are waiving your right to appeal, which means you're giving up your right to appeal. Do you understand that?
Yes, sir.
On the next document which is titled discovery certification, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Now, Ms. Kennedy, prior to signing these documents, signing and initial all of these documents, did your attorney go over these documents with you?
Yes, sir.
Do you understand, and did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Kennedy, are you a citizen of the United States?
Yes, sir.
State. I have before me state's exhibit. Hold on, let me back up. I think gotta put the cart before the horse. Now, Ms. Kenneth, in this document, I'll do this again. This information in clause number 331492, it alleges that you committed the class A misdemeanor offense of driving while intoxicated with alcohol concentration level of 0.15 or more. Do you understand that?
Yes, sir.
And it alleges that on or about October 15 of 2021, while you're in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the offense of driving while intoxicated with alcohol concentration level of 0.15 or more. Now, to this offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Now, you're pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
And Mr. Kimley, you advised and counseled Ms. Kenneth. Is there any evidence that she is currently mentally incompetent to stand trial?
No,
And Ms. Kenneth, your attorney, Mr. Kimler, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Kenneth, Ms. Kenneth, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
Your Honor, first, the state would like to offer into evidence exhibit 1 is the probable cause, is the plea agreement
Okay,
between the parties, and exhibit 2 would be the probable cause affidavit. We ask that the court take judicial notice of the PC affidavit in the court file.
okay, any objections?
Your Honor, I think that the judicial confession that she signed with a guilty plea was sufficient without the admission of a probable cause affidavit. So I don't understand the necessity of admitting the probable cause affidavit where you have a judicial confession.
But she already pled guilty.
Yes, sir, Your Honor. The probable cause affidavit has evidence of her BAC being over the 0.15 required for the class A misdemeanor plea. We're only asking that's in the court file to support the conviction.
She's pled guilty to that as alleged. It's an element of the offense as a class A.
Well, that's true, but I'll take judicial notice of probable cause affidavit as well. Okay, now,
And we do have a plea agreement, Your Honor.
and what is that agreement?
We're in exchange for defendant's plea of guilty in this case, the state is recommending confinement in a Jefferson County jail for a period of 1 year, Your Honor, 12 months, Your Honor. We're asking that the court suspend imposing that sentence at this time and instead place defendant on community supervision for a period of 12 months, Your Honor. Require defendant to pay a $750 fine.
$750.
Yes, sir, and to complete 48 hours of community
48.
service. We're also asking that the standard DWI conditions of probation include an interlock device, Your Honor.
Okay,
I don't think she has a vehicle.
Okay.
Right?
No, sir.
You don't operate a vehicle.
No, sir.
okay.
If you do, you have to have it.
Okay. Ms. Kennedy, state is offering that you serve is 12 months, it's 365 days in the Jefferson County Jail or fine, and that will be probated for a period of 12 months. And during the 12-month probationary period, now the 365 days, you will not be required to serve any time in jail because you'll be placed on probation for 12 months.
Yes.
During the 12-month probationary period, you'll be required to pay a fine of $750 plus court costs. The total fine and court cost is $1,217. You'll also be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month. You'll also be required to pay in monthly installments You'll also be required to pay the Jefferson County DWI education class and initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, your total monthly installments, that is the total amount that you will be required to pay while you're on probation, is $190 a month. Will you be able to pay the $190 each month?
Yes, sir.
You'll also be required to perform 48 hours of community service. You will be required to install an interlock device on any vehicle that you own or operate. You will be required to attend and complete a DWI education class and have a drug and alcohol assessment, and you'll be required to adhere to the other standard terms and conditions of probation. Now, Ms. Kennedy, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay. Ms. Kenneth, I'll follow the plea bargain agreements that you have entered into with the state. And Ms. Kenneth, this will conclude your case. You're gonna stand on the X next to your attorney, follow the directions right here. Yeah. Follow the directions of the clerk. Once you finish following the directions of the clerk, you'll be free to go and you have a blessed day.
Yes, sir.
Thank you.
So, are you?
Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been called for jury duty on a criminal case. The criminal case that we have is a misdemeanor case. Criminal cases are divided into felonies or misdemeanors. This is a misdemeanor case that you have been called for jury service on. You will be examined for inclusion on the jury hearing this criminal case. Our court hours are normally from 9 a.m. to 5 p.m. However, because we have large dockets in the morning from 9 to 12, sometimes to 1 o'clock, our court hours will be from 1:30 till 5 p.m. or sometimes it goes beyond 5 p.m. Whether or not you are selected for inclusion on this jury, you are serving a significant service which only free people can perform. If you are selected, this case will be tried expeditiously, consistent with justice, which requires a careful and impartial selection of jurors. Unless instructed otherwise, you will be permitted to separate for recess, for meals, and at night. Now, I must first administer to you the first of 2 oaths. So I need each one of you to raise your right hand, and then once I finish administering the oath, please say, "I do." Do you and each of you do solemnly swear or affirm that you will make true answers to such questions as may be propounded to you by the court or under its directions, touching on your service and qualifications as a juror, so help you God? Okay, you may put your hand down. The law requires that each of you must possess certain qualifications before you may be considered for jury service as a juror. Also, there are certain excuses and exemptions some of you may wish to claim. First, I would like to determine if you possess the qualifications for service on a criminal jury trial. It is very important that you answer these questions truthfully. If you do not, and the lawyers or I discover this fact after you are seated on a jury, the case could be retried and you may be held in contempt of court and placed in the Jefferson County Jail for up to 180 days and be given a fine up to $500. Now, I will ask you a series of questions. I do not want you to answer those questions out aloud. Just answer those questions to yourself. And once I finish asking the series of questions, I will then state, is there anyone in the panel who feel as though that they're disqualified? And if you think that you may be disqualified, just please raise your hand and we will ask that you will come up before the bench and we will discuss the matter more privately. And when I mean privately, we have a device here, a noise sound device that will be on, and plus we will turn off the mics so that only those of us who are at the bench will be able to hear. Okay, so the first question, except for failure to register, are you a qualified voter in Jefferson County? and in the state of Texas under the Constitution and laws of Texas? Have you ever been convicted of theft or any felony? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Now, I always pause here and explain. I have to ask this question. This is not a question that we're asking you personally or to embarrass anyone, but it's a question that by law I have to ask. And the question is as follows. Are you presently insane or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and reside in Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? Have you served as a petty juror for 6 days in the preceding 6 months in a county court or 6 days in the preceding 6 months in a district court? Is there anyone here that feels as though that they are disqualified? If you think that you may be disqualified, please raise your right hand. Let the record reflect that no one on the panel have raised their hand. So therefore, at this point, everyone is qualified. Now we will move on to exemptions. I will determine if anyone who is otherwise qualified to be a jury wishes to claim one of the following exemptions. You may claim any of the following exemptions if you choose to, but you are not required to claim them. If one of these applies to you, but you still desire to be considered as a juror, please continue to be seated. And I will ask the following questions in the same manner that I asked the questions to determine whether or not you were qualified. So I will ask questions, please ask them to yourself. And at the end, I will ask if anyone would like to claim one of the exemptions. First question, are you over 70 years of age? Do you have legal custody of a child or children under the age of 12 and jury service would necessitate leaving the child or children without adequate supervision? Are you a student in a public or private secondary school? Are you enrolled in and in actual attendance at an institution of higher education? Are you an officer or employee of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a petty juror in the county during the 3-year period preceding the date that you are asked to appear for service today? Are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? Are you a member of the United States military forces serving on active duty and deployed away or deployed to a location away from your home station and out of Jefferson County? Now, if these exemptions apply to you and you do not desire to serve as a juror, please raise your right hand. Let the record reflect that no one on the jury panel have raised their right hand. So no one is claiming an exemption. Now I must move to excuses. If any of you feel that there's a reason why you cannot serve, then I will ask that you will come up so that you can explain to the court why you cannot serve and basically what your excuse is. Now, A juror may be excused for observance of a religious holiday upon completing an affidavit as required by the Texas Code of Criminal Procedure, Article 29.012C. A juror may not be excused for economic reasons without the consent of the parties. That is, without the consent of the state, which is the district attorney's office who's trying the case, as well as the consent of the defense in this case. A juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Now, is there anyone that is wishing to claim an excuse? Let the record reflect that no one on the jury panel is claiming an excuse. So all of the jurors are qualified. We have no exemptions and no excuses. So at this time, ladies and gentlemen, you all are qualified. Now we will move on to what is called voir dire. As stated earlier, you have been summoned to court as prospective jurors in this criminal case. The defendant in this case is Mr. Chris Frank Polanco. And Mr. Polanco is represented in this case by attorney Rife Kimbler. Okay, y'all may be seated. The state is represented in this case by attorney Tommy Coleman and attorney Lamar Johnson. Our court reporter is Miss Ada Christie. Miss Christie will be taking down everything being said, so please speak up when you are answering or asking questions. The bailiff in the court is Mr. Charlie Porter. The defendant in this case is charged by information with the Class A misdemeanor offense of theft. And the punishment range for a Class A misdemeanor, if he is convicted, is confinement in jail for a term not to exceed 1 year, a fine not to exceed $4,000, or both such fine and confinement. The state and the defendant, through their attorneys, have the right to direct questions to each of you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not meddling into your personal affairs, but are trying to select fair and impartial jurors to hear and decide this particular case. If at any time you prefer to not answer any of the questions in the presence of the panel, just please say so, and I will ask that you will come up to the bench so that we can discuss it more privately. Is the state ready to proceed?
State's ready, sir.
And is the defense ready to proceed? Mr. Coleman, the panel is yours.
Thank you, Your Honor.
And you have 30 minutes.
I think I'll give the court back some time. Thank you, Judge.
Okay, you're welcome.
Good afternoon. Again, my name is Tommy Coleman. I'm one of the assistant district attorneys here in Jefferson County. I want to make sure that I'm speaking up loud enough for you guys to hear me back there in the back, Miss Oliver, Miss Teller, and Miss Frank. So if at any time I'm not speaking loud enough, just raise your hand and let me know. I always feel like I'm yelling at these four people in the front here. I'm trying to project to the back there. I have read your jury questionnaires, know a little bit about each and every one of you. So I think it's only fair to tell you a little bit about myself. In fact, I know Mr. Zakar, you're an engineer. Am I pronouncing that right? Zakar. Thanks. And at any point, if I mispronounce your name, just please just correct me. Mr. Enderley, I know that you're a mechanic. Ms. Wand, you work for Walmart, correct? Mr. Adair, Spindletop. Sure. And Ms. Taylor Christus. No. And Ms. Oliver, you work for the Social Security Administration. So since I know a little bit about each and every one, I think it's only fair to tell you a little bit about myself. But for the time I spent in the United States Army, I lived in Texas all my life. Undergraduate school in Texas, in Fort Worth, at Texas Wesleyan University, South Texas College of Law in Houston, and spent some time in working in Austin as an assistant staff attorney for the Texas Department of Criminal Justice. And I've been a prosecutor in a couple of other offices before making my way here to Jefferson County. I enjoy being a prosecutor, and contrary to what some people think, being a prosecutor is not about sending people to jail. It's not about wrapping up convictions. It's about seeing the justice done. By statute, we require we're required by statute to quote see the justice is done. And I want to see the justice is done for this community in this case. How do we get there? I need 6 of you who will hear the evidence in this case and hear that evidence, weigh the evidence fairly without any prejudice or bias, and render an opinion or a verdict in this case based solely on that evidence. And when I say bias or prejudice, we all, to a certain degree, have certain biases based on our life experience and our circumstances in life. Ms. Pritchard, you may have a favorite sports team, or Miss Bullen, you may prefer Pepsi over Coca-Cola, we all have things that we bring to the table, but what I want to know is if, in this case, if there are such things or biases that rise to the level where you might not be a fair juror. For instance, Mr. Grant, if your house was burglarized last night, and you show up here today to find out that this defendant's on trial for burglary, you might not be the best juror for this particular case when you're given that experience. Now, there is one thing I like to say is I used to apologize for the inconvenience that having jury service has on your life and the things that you can be getting done at work and the tasks, the to-do list you can be taking care of when you're sitting here. But I don't apologize for that anymore because this is important. It's important to the district attorney's office. It's important to this defendant. It's important to our criminal justice system. And I think that if you or a family member, Mr. Kelly, were on trial, you'd want jurors to show up, give this their undivided attention without thinking about work, without thinking about the other things that they can be getting done. In fact, while you guys were sitting out there before the bailiff called you in, we disposed of 3 cases. 3 cases played out because of the fact that you were out there waiting and willing to hold the state and the defense accountable and hear the case. So the mere fact that you're here helps us move cases. So I don't apologize anymore for the inconvenience. But what I will do is I will do my very best to move through this material as quickly as possible and not waste any more than what's necessary to figure out what we need to figure out. So with that being said, I can't talk about what this defendant is charged. I can't talk about facts. I can't say that he's charged with theft. He's a misdemeanor theft. The judge alluded to what the punishment range is, up to a year in jail, up to a $2,000 fine, up to a $4,000 fine, and probation to be under service. So fortunately, nobody's looking at any prison time in this case. Fortunately, those of you who are chosen to serve on this jury won't have to look at any autopsy photos, or fortunately, this is not going to be one of these high stress, emotional trials that we sometimes have here in the court. And I'll add one other thing. I expect this trial will be concluded by the end of the day. It's just that straightforward. The law under Chapter 31 of the Texas Penal Code says that a person commits the offense of theft if a person unlawfully appropriate property without the consent of the owner. I think it's pretty straightforward. I'm not gonna spend a lot of time on that definition. Mr. Robertson, I mean, does it make sense to you if somebody unlawfully takes your property without your consent? They've committed the offense of theft under the eyes of the law. You know, I mean, there are times with the law, and it can be confusing, particularly the way sometimes the legislature writes the law, but I think this is pretty straightforward. Is there anybody here who is not clear on what the law says, or the elements of the offense of theft as it relates to the law in Texas? Raise your hand. Ms. Point, you have any questions about the law of theft and how it's proven? Unlawfully appropriate, in other words, exercise control over or take somebody's property without their consent. Pretty straightforward. Mr. Zakar?
What figures it doesn't have to be aware that they didn't have the consent of the other party to.
I think that can be, this is one of those instances where your common sense comes into play. You as jurors get to apply your common sense to
A reasonable person.
well, yeah, you get to apply your common sense to the facts and to the law in this case. I'll give you an example since you brought up Mrs. Zakar. You've all been to the bank or some of these institutions where you have to sign something there and they have the pen either on the little chain or on the they have this big like flowery thing on the top of it, so it's not desirable for you to take and stick in your pocket. I think in that instance, is it fair to infer that you don't have their consent to take that pen if they attached it to a chain?
Yeah.
You know, or if they've taken the time to put one of the big feathers on the top of it, so that you don't want to walk away with it. So I wish I had a better, more concrete answer for you, but generally speaking, you as a juror, using your common sense will get that to be able to make that as to whether or not, given the evidence and given the facts as they were presented to you, this person knew or didn't know they had to take the property. Does that answer your question?
Yeah.
Okay. I mean, I think, yeah, I'll just leave it there. Any other questions about unlawfully appropriating somebody's property without that person's consent? Pretty straightforward. Sometimes we get jurors in here in different cases, they say, well, I don't agree with that law. You know, I think that law is a stupid law. I think we can change the law. Sometimes we get those instances with the drug cases, Mr. Adair. Nowadays, you know, there's some folks that say, with marijuana, let's legalize it or decriminalize it. And I get it, that's your opinion. You know? And now's the time to express your opinion. But I guess what I'm getting at is I want to know right now, is there anybody who disagrees with the law of theft? You know, says we shouldn't have a law that says or criminalizes somebody taking your property without your consent. Now's the time to raise your hands. Miss I'm gonna get it right for it. It's a Fontanza. Fontanza. I mean, it makes sense, right? I mean, because if we didn't have a law to prohibit somebody from taking your things, I mean, like the wild, wild west, anybody can just take your stuff. You know, so, I'm not gonna spend a lot of time on that because I don't think there's anybody here who would think that we should do away with the law to prohibit somebody from taking your property. It's Della Rue, you're from Cushing, you've been quiet, I haven't asked you a question. Any thoughts on it so far?
Sir.
All right, very good. Okay, so the law in Texas, as it relates to theft, has what we call a value ladder. I'm not gonna spend a lot of time on that, except to say that the severity of the punishment is correlated with the amount that is the value of the property is taken. For instance, Mr. Campbell, in the state of Texas, if it is proven and the defendant is found guilty of taking or appropriating property of a value less than $100, then it's a Class C, punished with about $5. Ms. Juan, if they're found to have appropriated or found guilty of taking property from $100 to $750, Class B misdemeanor, punishable by only jail time of up to 180 days in jail. And still yet, Ms. Oliver, on it's a Class A misdemeanor, what the defendant is charged with, if it is proven that they have taken property of a value between $750 and up to $2,500. And I say that to say, does anyone have a problem with the fact that the legislature has said that the greater the value of the property that you're taking, the greater the punishment? Anybody, raise your hand. It's, Frank, I was talking to you, what do you think about that? Now, the more you steal, the potential is the greater the punishment you face. A good idea or a bad idea? Anybody else, any thoughts on that? You know, I'm kind of blowing through this pretty quickly, but I think this is a pretty straightforward law, and I think this is pretty straightforward. So I'm gonna spend a lot of time on this, and I just have something they want to share. It's pretty. No? All right. Can anybody consider the full range of punishment? Is there anybody here who says, if I find this defendant guilty beyond a reasonable doubt, and we'll talk about what beyond a reasonable doubt is here in a second. Is there anybody here who says, if I find this defendant guilty beyond a reasonable doubt, I could not even consider the full range of punishment? Meaning I couldn't even consider a fine of up to $4,000, or I could not even consider jail time of up to a year, or I couldn't even consider probation. Well, why am I talking, Mr. Kimmel, why am I talking about punishment if they're not going to set punishment? Let me change that. Here in the state of Texas, a defendant, trials are bifurcated, meaning they are in two separate phases. And if the defendant has the option to elect, if they're found guilty, for the court to assess punishment as opposed to the jury. And so the fact that I'm asking you about whether or not you can consider the full range of punishment is really not relevant in this case, because the defendant has elected for the judge to assess the punishment if he's found guilty. So never mind on that question about whether or not you can consider the full range of punishment, because those of you who are chosen to sit on this jury, if you find the defendant guilty, you will not even consider the punishment for the court will. But that does bring me to another point. I've had jurors in the past who have said the point that if I assess punishment, if I find someone guilty, I want to have a hand in assessing punishment. Is that something that any of you have a problem with? In other words, could you find a person guilty if you believe beyond a reasonable doubt they are guilty, and do so knowing that you won't play a role or have a say in the future? Well, in this case, the defendant has said that he would ask the court to assess his punishment if he's found guilty. And I just want to make sure there's no one here who says, well, wait a minute, I want to do both, and I can't assess or determine guilt or innocence if I can't play a role in in the type of punishment the defendant receives. If that makes sense.
No.
Let me give you another shot, Mr. Dare. Juries can find people guilty, and the defendant can elect to assess punishment. Okay. Juries can find people guilty, and the judge can assess punishment. Okay. Now, if you're a juror, what I want to know is, could you do that, knowing that if and when you find someone guilty, you won't be playing a role in assessing the punishment? Is there anybody else who would have an issue with that? Is there anyone who has a problem with that? All right, thanks for the point. Thank you, Mr. Mayor. Now, beyond a reasonable doubt, there is no definition of what beyond a reasonable doubt is. That's a standard by which we've got to prove those elements of the offense. In other words, I have to prove, the state has to prove beyond a reasonable doubt that the defendant unlawfully appropriated the property and the defendant did not have the owner's consent. Now, what is beyond a reasonable doubt? I can't define it for you because the law doesn't give you a definition. It is personal. It is internal. It is whatever you believe beyond a reasonable doubt to be that standard of proof that you believe the state has met, that if there is a doubt, it's not a reasonable doubt that the person committed the offense. So while I can't tell you what the definition of beyond a reasonable doubt is because there is no definition, I can tell you what it is not. It is not 100% proof. It's not 100% certainty. Mr. Robertson, I am not required by the state of Texas or by the law to prove my case to you with 100% certainty. Just to a degree that you believe that if there is a doubt that exists out there, if it's not a reasonable doubt, then what, in your belief or in your estimation, based on your comments, then, that should be it. Does anybody have, let me ask it this way, is there anybody here, knowing that the law does not require me to prove my case with 100% certainty? Is there anyone here who would still require 100% proof? Is there anybody here who requires satellite photos, DNA, 12 nuns who saw it? I gotta bring them in, all in here. I mean, because you think about it, I mean, Mr. Phelan, Pullen, you're smiling, but if you think about it, what's really the only way for you to know something happened to 100% certainty? Well, it's possible if you were there. You know, if you witnessed it yourself, it's possible. But if you were a witness to it, then you would be on my witness list. So the law recognizes that. The law does not hold me to that standard. But make no mistake, there will be evidence in this case. Make no mistake, it's my position that we will prove our case beyond a reasonable doubt. The defendant enjoys certain rights, and that's one of the rights is to have his case proved beyond a reasonable doubt. Now, another right that the defendant has, Ms. De La Rue, is to be presumed innocent. Okay, as he sits here right now, without having heard any evidence or testimony, if I were to ask you to vote on his guilt or innocence, what must your vote be? What must your verdict be at this point? That's right. He's not guilty. He's innocent at this point because you haven't heard any testimony. He's presumed innocent. Okay, that's his right. He also has the right not to testify. If he elects at the end of this trial or during this trial not to testify, the law says you cannot hold that against him. Now, you may want to hear from him. You're only human, Mr. Enderley. You may want to hear from him. You may say, if it were me, I would take that stand. I would shout it from the rooftop. I'm not against you, but you know that the law is required, and the law says you can't use that. Is there anybody here who could not follow that law, who could not, if the defendant elects to testify, who could not set that aside and wouldn't hold that against the is there anyone here who has been impacted by a theft? You know, sometimes with the DWI cases, someone would be a victim of DWI or have a friend or family member who is a victim of DWI. I can't sit on this jury, but brings a bad memories again. Back to talking about bias, couldn't be fair. What I want to know is similarly is if there's someone with a victim here of a theft, or have a friend, a close family member who's a victim of a theft, if it would impact your ability to listen to the evidence in this case and be fair and more. Had your favorite ring stolen or something like that? No. Does anybody know the defendant, Mr. Chris Polanco? Does anybody know his defense counsel, Mr. Ryan Kimler? Is there anything as it relates to the theft or the law of theft or potentially the issues in this theft case that you can think of that, you know, perhaps you may want to raise at this point? I didn't touch on. All right, thanks, guys. I appreciate your time and attention. Look forward to presenting my case to the 6 of you who are chosen.
Mr. Kimler, panel is yours.
How many of you would stand in here and ask yourselves, I wonder what that guy did wrong? Anybody? Curious? Yeah. Why'd you take that? Mr. Look, what is it? Zacher. I'm sorry? Zacher. Why'd you ask yourself that, Mr. Zacher?
Curious, or gotta be here for a reason.
You gotta be here for a reason. The reason is that he's charged with an offense, right? And just because somebody's charged with an offense, does that mean that they've done anything wrong? Right. The fact that somebody's charged with an offense and has to come in to defend the case for the jury, it's not evidentiary. The information isn't evidentiary. It's just the methodology by which the jurisdiction of this, in this case, the county court is involved to bring in people from the community and panel and jury to hear evidence. And the state, of course, is the party required to produce evidence. And that evidence has to be with sufficient quality and quantity to convince you beyond a reasonable doubt that the person did what they're charged with, convicted of it. And then what's the result of conviction? Anybody, what happens after somebody's convicted? They're punished, right? So the real question that you have here, those of you who are going to be selecting the serve, is has the state presented to you sufficient evidence to warrant a conviction and punishment, right? And punishment can consist of up to a year in jail in this case. So the fact that the state is trying to put potentially Mr. Polanco in jail for a year, that's not decided by any law enforcement official or any judge or any member of the government. That's decided by the people from the community, but that power rests with the community via the jury system. So that's what we're here today. And as far as the actual selection of the jury, we start out with those of you that receive the jury summons. I guess you get it electronically or in the mail, and you go online and register and you come back up. So already you can see that you're limited with the people that show up for the ones that actually go online and register, right? That's the first call. Because you could easily just, those of you that receive the summons, not go and register. How are they going to show that you even received the summons? That's the first call of the people from the community as far as what we end up in juries, is the people that bother to go online and register. And then you get the second, well, I guess is the second call, you know, or third, the people that are excused. And we had 4 people excused off of this panel, and then you got one that's a no-show. So the 20 people that are supposed to be here, we end up with 50. And for what it's worth, we're starting to get 2 fewer people. So that's true on this community telling us. So I first of all want to thank y'all for showing up and appreciate you being here, because we don't. I really think jury systems are something that we take for granted here in the United States. That power rests here. Mr. Coleman's talked about his history a little bit. For what it's worth, tell you mine a little bit. I'm originally from Nederland here, went to University of Texas undergrad. And then before I went to law school, did a summer semester in the Soviet Union in 1986 at Leningrad State University. And that's where I decided to go to law school. Because you see what happens when, you know, the government can just run over people. And I found myself answering questions there, the Soviets, the Russians that you deal with. What would happen in the United States if this, you know, happened, this debate, the government tried to do this? And well, you got to get a lawyer. You know, I said that so much that I finally decided, oh, geez, maybe I shouldn't be a lawyer. So came back here, went to University of Texas Law School, and been doing this, you know, now for the last 32 years. So that's the importance of the jury system. And again, that was reinforced to me when I went back in 2019 and did a semester at Moscow with the Higher School of Economics in Moscow. And you would see in the modern Russian system, although they have the right to a jury in the Constitution, well, the government's gone back and said, well, yeah, you've got that thing called a jury trial. We put that in the Constitution in 1991. But you know what? You're not going to get a jury trial if it's crimes against the state. So any crime against the state, and that would be anything from like what we would call an assault on a public servant to, in their case, authorized demonstrations. You have to have a permit to have a rally and political rally in their demonstration. If you have a permit, you can be prosecuted. Well, there's no jury for that. And people get some rather severe sentences for just getting together and having an unauthorized demonstration against the government. And you don't get a jury to decide what happened. And, you know, even further, you know, at least in Texas, you get a jury to decide punishment, right? You know, and that's just not another place. So it's something that we, you know, hopefully don't ever take for granted and all this stuff. So I'll get off of my soapbox with that. This is a relatively simple case. Proof beyond a reasonable doubt is not going to be defined for you. I'll simply suggest it's a high burden of proof. Each of you will be deemed competent by the the judge and the court's instructions, they're gonna give you to come up with your own definition of how high a burden of proof that is. None of them will be incorrect. It'll help each of you how high a burden to hold the state to. I suggest to you there's a high burden of proof, because again, what we're talking about is potential confinement, loss of liberty, those kinds of things that are the consequences of the guilty verdict. And really, that's about all I have. Mr. Coleman covered the fact that any of you that have been victims of theft or something like that, that may carry with you some sort of, I hate to say bias or prejudice, perhaps in this type of case. If you can identify yourselves, I think you might not be able to be fair and impartial because of being a victim of theft. Anyone? You ask that question a lot in DWI cases. You always have somebody or a group of people, unfortunately, that have been a victim of an intoxicated driver, or have a family or friend who's been a victim of an intoxicated driver. It's kind of the same idea, it's just because of your personal experiences or the experiences of loved ones or people that are close to you with a particular type of offense. You might not be able to be fair in that type of offense. But I take it all of you can be fair in a theft case, is that right? All right, that's all I have. Thank you. Yeah. Oh, I'm sorry.
Yeah.
Ms. Pritchard, is that right? Okay, so you think you can be fair? Right, actually, well, like, let's say for instance, you got sworn that somebody broke into your car and you come in there for jury duty, started with it, might not be, right? Okay, so you could be fair and impartial, right? Everybody else? Okay, thank you.
Okay. Ladies and gentlemen of the jury, we're gonna ask that each one of you follow the bailiff into the hallway. We may ask some of you to come back into court to do some follow-up questions. And at this time, the court will be in recess to give you an opportunity to go out into the hallway. Everyone, please stand while the jury, while the panel leave the courtroom. Mr. Kimler.